The landscape of American firearms law is perpetually shifting, but certain moments act as seismic events, reshaping the legal terrain for millions of citizens. For the average person, understanding these changes is not about preparing for a speculative confrontation or engaging in political debate. It is about maintaining the ability to navigate daily life without inadvertently crossing the line into criminal conduct. The legal information discussed in this context is vital because it directly impacts the most mundane yet essential aspects of modern existence. Going to the grocery store, visiting a gas station, dining at a restaurant, or walking through a shopping mall. When the Supreme Court issues a ruling on the Second Amendment, it does not merely decide an abstract legal question. It redefines the relationship between the individual, the state, and private property. It establishes the rules of the game for how law-abiding citizens can exercise a constitutional right in spaces that are, paradoxically, both open to the public and owned by private entities. As we explore the potential implications of the court's recent engagement with these issues, one fundamental question emerges for every citizen to consider. If you hold a permit to carry a firearm for self-defense, should you be required to ask for permission from a corporate office before you can legally walk into a supermarket? Or does the right to self-defense imply a presumption of access to public spaces unless the owner explicitly says otherwise? To understand the magnitude of the current legal moment, we must first establish a clear picture of the existing legal framework governing firearms in the United States. This framework is not a single, monolithic set of rules, but rather a complex, layered system. At its base is federal law, which establishes the minimum standards for who can own a gun and how they can be transferred. The Gun Control Act of 1968 and the Brady Handgun Violence Prevention Act set forth the fundamental criteria. Individuals are generally prohibited from shipping, transporting, receiving, or possessing firearms if they have been convicted of a felony, are fugitives from justice, are unlawful users of controlled substances, have been adjudicated as mentally defective, or are subject to certain restraining orders, among other categories. These federal disqualifiers apply uniformly across the country. Furthermore, the National Firearms Act imposes strict regulations on specific categories of weapons, like short-barreled rifles and suppressors. Federally licensed dealers are required to initiate a background check through the National Instant Criminal Background Check System before transferring a firearm to a purchaser. This is the federal floor, the baseline upon which all other regulations are built. However, it is the relationship between federal and state law that creates the intricate patchwork citizens must navigate. The general rule is one of federal supremacy, but the Second Amendment, as interpreted by the courts, places limits on both. States are free to enact laws that are more restrictive than federal law, but they cannot legalize what federal law prohibits. This means that a person who is not a prohibited person under federal law may still be barred from purchasing or possessing a firearm by state law. For instance, some states have expanded the list of disqualifying offenses to include certain misdemeanors or have imposed waiting periods beyond the instant background check. Others have enacted universal background check laws that extend the requirement to private sales, which are generally unregulated at the federal level. This is where the concept of permit systems becomes critically important. States have developed various mechanisms for licensing either the ownership or the carry of firearms. These range from permits to purchase, which often require an application and background check before a firearm can be bought, to permits to carry a concealed handgun, which authorize an individual to bear a firearm outside the home. The standards for obtaining these carry permits have themselves been a subject of intense constitutional scrutiny. Prior to the Supreme Court's intervention, states generally fell into two categories: may issue and shall issue. In may-issue jurisdictions, local authorities had significant discretion to deny a permit even if an applicant met the basic criteria, often requiring the applicant to demonstrate a special need for self-defense. In shall-issue states, authorities were required to issue a permit if the applicant met objective statutory criteria like passing a background check and completing a training course. The Supreme Court's 2022 decision in New York State Rifle and Pistol Association v. Bruin fundamentally altered this dynamic, striking down New York's may-issue regime and affirming that the Second Amendment protects an individual's right to carry a handgun for self-defense outside the home. This decision did not eliminate all permitting systems, but it mandated that they must be administered based on objective criteria, effectively requiring most states to operate as shall-issue jurisdictions. The Bruin decision also introduced a new, dominant framework for evaluating gun laws. To be constitutional, a regulation must be consistent with the nation's historical tradition of firearm regulation. Courts must now look to history to determine if a modern law is permissible, asking whether there is a comparable historical analog from the founding era or the Reconstruction era that justifies the restriction. It is directly from the crucible of Bruin that the current legal dispute, often characterized in public discourse as the court ending gun permits, was born. In response to the Bruin decision, which mandated that citizens have a right to carry in public, several states sought to define the boundaries of that right, specifically concerning where one could carry. Hawaii, the state at the center of the case Woolford v. Lopez, enacted a law in 2023 that created a unique default rule for private property that is open to the public. The law made it a crime for a person with a valid concealed carry permit to bring a firearm onto such property unless the owner, lessee, operator, or manager of the property gave express authorization, either through clear and conspicuous signage or through direct verbal or written consent. This applied to a vast array of locations that are essential to daily life: grocery stores, gas stations, restaurants, shopping malls, banks, bars, and even beaches and parks managed by private entities. The practical effect of this law, according to its challengers, was to nullify the right recognized in Bruin. Since very few property owners proactively post signs or give explicit permission for firearms, the law effectively created a default gun-free zone across most of the state, relegating the right to carry to the narrow confines of one's own property or the public sidewalk. The state of Hawaii, in defending its law, argued that it was not regulating the right to bear arms per se, but rather vindicating a fundamental, ancient right of property owners, the right to exclude. They contended that no one, including a permit holder, has a constitutional right to enter private property with a weapon against the owner's wishes. The state pointed to historical laws, including an 1865 Louisiana statute and a 1771 New Jersey law, as evidence that such restrictions on entering private property with firearms were part of the American legal tradition. This legal argument created a direct conflict between two constitutional considerations: the Second Amendment right to keep and bear arms and the common law right of a property owner to control their premises. The case wound its way through the federal courts, creating a split in judicial opinion. A panel of the Ninth Circuit Court of Appeals upheld the Hawaii law, finding that the historical statutes cited by the state were sufficiently similar to serve as analogs under the Bruin test. However, the Fourth Circuit, in a separate but similar case from Maryland, Kipke v. Moore, struck down a comparable provision in Maryland's law, specifically holding that prohibiting guns on private property open to the public was unconstitutional. The Fourth Circuit reasoned that such a prohibition was directed at gun owners, not property owners, and that the historical laws cited were outliers, often enacted for discriminatory purposes like the suppression of the rights of newly freed slaves in the post-Civil War South, and thus were not indicative of a robust American tradition of firearm regulation. This split between federal circuits made Supreme Court review virtually inevitable. When the Supreme Court heard oral arguments in Woolford v. Lopez in January 2026, the justices' questions provided a window into their thinking and hinted at the profound implications of the eventual ruling. The arguments revealed a court deeply engaged with the practical and historical dimensions of the case. Chief Justice John Roberts probed the logic of requiring affirmative consent, drawing a powerful analogy to the First Amendment. He questioned whether a property owner would need to post a sign to allow someone to hand out political leaflets on the sidewalk in front of their house, suggesting that the default expectation in public-facing spaces is one of access, not exclusion. This analogy struck at the heart of Hawaii's argument, suggesting that the default rule for property open to the public might be permission to enter for lawful purposes, rather than a presumption of exclusion that must be overcome. Justice Neil Gorsuch focused on the historical evidence, specifically the state's reliance on the 1865 Louisiana Black Code. He pressed the state's attorney on how a law enacted to disarm and control freed slaves could be considered a dead ringer for a constitutional tradition that the 14th Amendment, adopted shortly thereafter, was designed to correct. This line of questioning suggested a deep skepticism about using laws with a patently discriminatory and unconstitutional purpose as a justification for modern restrictions. On the other hand, Justice Ketanji Brown Jackson raised a different concern, acknowledging that after Bruin declared a right to carry outside the home, states were understandably trying to figure out how to protect the well-established right of property owners to control their land. She framed the dispute as a direct clash of rights that required judicial clarity. So, what does this mean for the average citizen and for the legal landscape of every state? If the Supreme Court rules against Hawaii and strikes down the law, it would fundamentally affirm a default rule of access. The decision would clarify that the Second Amendment right to carry a firearm for self-defense extends into the privately owned spaces that the public is invited to use. In practical terms, this would mean that a valid permit holder could lawfully enter a grocery store, a mall, or a bank without first checking for a sign or seeking managerial permission. The right would not be absolute, of course. The property owner would retain the ultimate authority to exclude, but they would have to exercise that authority actively, instead of a law that criminalizes the permit holder's entry. Unless the owner says yes, the default would shift to the owner having to say no. This is the rule that currently exists in the vast majority of states. Property owners who do not want firearms on their premises would still be able to post conspicuous signage prohibiting them, and entering in defiance of that sign would constitute trespassing. The crucial difference is that the burden of action shifts from the individual citizen to the property owner. The citizen would no longer be a potential criminal for simply walking into a store, but only if they ignore a posted rule. This approach, as noted by the Solicitor General's office in their brief supporting the challengers, aligns with how other constitutional rights are treated. A state could not require citizens to get a property owner's permission before exercising free speech on premises open to the public, and the argument follows that the Second Amendment should not be treated with unique hostility. However, the implications extend far beyond the simple act of entering a store. A ruling in favor of the Hawaii permit holders would likely have a sweeping preemptive effect on similar laws in other states. Following the Bruin decision, several states, including Maryland and others, passed legislation attempting to designate large swaths of public and private property as sensitive places where guns are prohibited. The Maryland law, for instance, banned guns in a wide range of locations, including places of amusement, healthcare facilities, and areas within 1,000 feet of a public demonstration. The Fourth Circuit's ruling in Kipke v. Moore has already created a precedent in that circuit that such bans on private property are unconstitutional. A Supreme Court ruling in Wolford would settle this question nationally. It would likely invalidate provisions in any state law that automatically ban firearms from categories of private property that are open to the public, forcing states to rely instead on property owners to post their own restrictions if they so choose. This potential outcome also illuminates a common misunderstanding among the public regarding the nature of constitutional rights and private property. Many people assume that a business open to the public is a public place in the fullest sense of the word, subject to the same constitutional rules as a government building. This is incorrect. A privately owned shopping mall is not a public forum in the same way a city park is. The owner of that mall has significant rights to control the property, including setting rules for conduct. The constitutional question in Wolford was not about whether property owners have that right, but rather whether the state can step in and, by default, impose a specific rule on behalf of all property owners without requiring them to act. It is the difference between a state saying, all mall owners are presumed to ban guns unless they say otherwise, versus, mall owners may ban guns if they choose, and here is how they can do it. The court's decision will determine whether states can use their police power to create a massive default gun-free zone or whether the choice must remain with the individual property owner. Beyond the where of carrying a firearm, this case touches on the core legal responsibilities of gun owners. Regardless of the outcome, the responsibility to know and understand the law does not diminish. If the court creates a national standard where the default rule is access, unless the owner opts out, the responsibility shifts to the gun owner to be aware of and obey posted signage. A sign that says no firearms on a business would carry the full weight of law, and ignoring it would subject the permit holder to trespassing charges. This places a premium on situational awareness and the simple act of looking at a door before walking through it. Conversely, if the court were to uphold the Hawaii law, the burden on the gun owner would be exponentially higher. It would require the permit holder to ascertain the policy of every private business they enter before they enter it. In the absence of a sign, they would have to assume entry is illegal. This could involve seeking out a manager, asking for permission, and potentially being recorded or denied. For many, this practical burden would be so onerous as to make carrying a firearm for self-defense effectively impossible in the vast majority of their daily lives. It is also crucial to place this case within the broader context of ongoing legislative activity across the country, as it is not the only legal front where the rules are being contested. At the same time, the Supreme Court was considering Woolford. State legislatures were actively debating and passing their own gun laws. In states like North Carolina, the debate over constitutional carry or permitless carry continues, with efforts to override gubernatorial vetoes and allow citizens to carry concealed handguns without a permit at all. This represents a different kind of deregulation, one focused on eliminating the permit requirement entirely, not just defining where a permit is valid. Conversely, in states like Illinois, lawmakers are pursuing innovative and legally complex strategies to regulate the firearms industry itself, such as the Firearms Industry Responsibility Act, which attempts to hold manufacturers liable for marketing practices, seeking a workaround to the Federal Protection of Lawful Commerce in Arms Act. In Wisconsin, similar efforts to pass permitless carry are met with the reality of a gubernatorial veto, highlighting the intense political and legal battles happening in the states regardless of the Supreme Court's direction. Furthermore, the court's docket includes another significant Second Amendment case, United States versus Hamani, which asks whether the federal ban on firearm possession by unlawful users of controlled substances is constitutional. This case will test whether historical bans on arming habitual drunkards can serve as an analog for disarming modern drug users, even when they are not actively under the influence. The outcome could redefine the scope of prohibited persons under federal law. The real-world implications of the Woolford decision, then, are multifaceted. For the law-abiding citizen, it will bring clarity to a question that currently has no uniform answer. It will determine whether the right to self-defense stops at the parking lot of a grocery store or accompanies them through the aisles. For businesses, it will clarify their role in the regulatory scheme. A ruling for the permit holders would empower them to make their own choices through clear signage, making them the active decision-makers. A ruling for Hawaii would make them passive beneficiaries of a state mandate, where they are presumed to be gun-free zones without having to lift a finger. This also has implications for the legal concept of notice. Which system provides clearer notice to the citizen about what is permitted? A sign on a door provides immediate, unambiguous notice. A state law requiring a citizen to research the policy of every privately owned business they enter, or to seek out an agent of the company to ask for permission, provides a much higher barrier to compliance. Moreover, the court's decision will serve as a crucial test of the historical methodology established in Bruin. The justices' treatment of the 1865 Louisiana law, in particular, will send a signal about what kinds of historical laws are considered valid evidence of an American tradition. If the court rejects the use of laws that were explicitly part of the racist black codes, it will establish an important boundary, preventing states from resurrecting the most shameful parts of legal history to justify modern restrictions. This would align with the understanding that the 14th Amendment was intended to dismantle such laws, not to serve as their foundation. As one commentator noted, using a black code to restrict a right protected by the 14th Amendment is a deeply flawed legal argument, as it relies on the very evil the amendment was designed to eradicate. Navigating this environment requires a clear-eyed understanding of the distinction between a constitutional right and the regulations that govern its exercise. A common misunderstanding is that a constitutional right is absolute and cannot be regulated. This is false. The government can regulate the time, place, and manner of exercising rights, as long as those regulations are reasonable and do not unduly burden the core of the right. For example, the First Amendment right to free speech does not mean you can shout in a library or broadcast on a frequency reserved for emergency services. Similarly, the Second Amendment right to bear arms does not mean you can bring a gun into a courthouse or a sensitive location, like a polling place. The Bruin decision acknowledged this explicitly, noting that prohibitions on carrying in sensitive places are presumptively lawful. The core debate in Woolford was about whether a privately owned grocery store qualifies as a sensitive place akin to a courthouse, or whether it is a public-facing space where the right to self-defense should hold sway. The court's answer to that question will shape the legal landscape for a generation. For the gun owner, the legal responsibilities remain stringent regardless of the outcome. Federal law still prohibits possession by anyone who falls into a prohibited category. The Firearm Owners Protection Act still provides protections for those lawfully transporting firearms through jurisdictions with strict laws, provided the firearms are unloaded and inaccessible. State laws regarding magazine capacity, safe storage, and duties to inform law enforcement during a traffic stop are still in full effect. A Supreme Court ruling that clarifies the right to carry on private property does not grant immunity from other laws. It merely adjusts one variable in a very complex equation. As the Rand Corporation's research on licensing and permitting shows, these laws have varying degrees of evidentiary support for their effectiveness in reducing violent crime or suicide, but they are a permanent feature of the legal landscape that citizens must navigate. In terms of practical legal guidance, the most prudent approach for any citizen is to remain informed and adaptable. If the court strikes down laws like Hawaii's, it does not mean that every business will become a free-for-all. It means that businesses that wish to remain gun-free will need to post signs. Citizens must respect those signs. The law will move from a system of implied prohibition to a system of express prohibition. This is a shift from allowed only if the owner says yes to allowed unless the owner says no. It aligns the legal default with the physical reality of a public-facing business, an invitation to enter. Conversely, if the court upholds the law, it will validate a system where the default rule is prohibition, placing the onus on the individual to either avoid the property or seek permission. This would create a massive compliance burden and likely lead to a surge in litigation over what constitutes express authorization and whether digital policies or corporate hotlines satisfy the requirement. From a professional standpoint, this case is a fascinating study in constitutional interpretation and the balance of rights. The tension between the Second Amendment and property rights is real, and the court's resolution of it will be a defining moment. My personal insight, offered in an educational context, is that the vampire rule analogy used during arguments was particularly potent. The idea that a citizen must be invited in to exercise a fundamental right, when the public is otherwise freely invited to enter, strikes at the heart of what it means for a right to exist in daily life. If a right requires you to ask permission from a private party before you can exercise it in a space open to you, is it truly a right or is it a privilege that can be revoked at the doorstep of every commercial enterprise? This case forces us to answer that question. As we look toward the final decision, expected by late June 2026, it is essential to cut through the political noise and focus on the legal mechanics. The Supreme Court is not ending gun permits in the sense of eliminating the requirement for a license to carry. Permits will still exist in many states as a mechanism for ensuring individuals are trained and background checked. The question is about the scope of that permit's validity. The court is deciding whether a permit, once issued, grants you the right to enter the stream of commerce, or whether that right is suspended the moment you step onto property owned by someone else. The answer will redefine the public square. It will determine whether the right to self-defense is a companion that stays with you throughout your day, or one that must be checked at the door of every store, restaurant, and gas station you visit. For the millions of Americans who hold carry permits, this is not an abstract legal theory. It is the reality of their daily lives. And for the legal system, it is the next critical step in a long journey to understand the full meaning of the Second Amendment in the modern world. The decision will undoubtedly be met with both praise and criticism, but for the legal educator, the focus must remain on what the law is, how it changes, and how citizens can responsibly and lawfully navigate the new terrain it creates.